The President, please be seated. The court is now back in session. During this following session, the Chamber would like to hear from counsels for Mr. Kilsampon regarding the documents presented by the co-prosecutor and the lead co-lawyers for the civil parties during the key documents presentation on the 24th to 27th of June 2013. Before handing over to counsels for Mr. Kilsampon, the Chamber wishes to ask a question to Mr. Kilsampon. Mr. Kilsampon, can you please rise? The question is, if the Chamber applies the conditions as requested by the co-prosecutor regarding time allocation for the defense counsel and certain documents so that counsel can be prepared and that questions can be put to them. Could you please tell the Chamber what your reaction would be? Would you maintain your position as always? In other words, would you wish to exercise your right to remain silent, or would you like to respond to such conditions if they are offered, as I already mentioned? Mr. Kilsampon, Mr. President and Your Honors, and good morning again, everyone in and around the courtroom. The reason I have exercised my right to remain silent, this exercise does not limit to the fact that the court has not entertained my requests as indicated. There are other legal implications behind this decision, and I may only refer to one of them. There has been an attempt to prevent my counsels from properly or fully and meaningfully represent me in this courtroom. For example, that my counsels are allowed to write in the closing statement up to 100 pages only. And this is, to me, part of the court intention to prevent my counsels from properly represent me in the courtroom. I think that is only one of the reasons behind it, and I thank you very much. The President, thank you. I would like to know whether judges of the bench would wish to have any questions for Mr. Kilsampon. Judge Lavanya, you may now proceed.
In the interest of perfect clarity, this morning we have heard some suggestions made by the Office of the Co-Prosecutors. These suggestions would tend to allow the Kilsampon defense team to prepare for questioning of their accused client. With respect to the additional allocation of time for the questioning of the accused, this would allow for advance notice to be given to the accused with respect to the subjects to be addressed in addition to the list of documents. I hope that this has been taken into account by the Khieu Samphan defense. I also trust that the defense team has heard the request of the co-prosecutors, which consists of reiterating the ruling of the chamber on the possible consequences of a refusal to answer questions at this particular stage of the proceedings. What I mean by that is that the defense for Mr. Khieu Samphan, as well as Mr. Khieu Samphan, has stated that some of their rights have not been respected, and that they indicate exactly which rights have not been respected and demonstrate how this is the case. As well as an indication of the total number of pages as was raised, how this particular issue is at all related to Mr. Khieu Samphan's willingness to answer questions. Counsel Verken, I shall endeavor to answer that host of questions. Obviously, my position has been developed through all of our written filings as well as our oral submissions. Over the course of these proceedings, we have made many applications as well as arguments. I've stated today, as I've stated earlier, if the trial chamber is not to cut off my microphone, well, I shall show you that Mr. Khieu Samphan's fair trial rights have been violated. You have determined a threshold for the admissibility of documents, a threshold that is extremely low. You have abided by only a prima facie principle. We have had at least 4 hearings on the admissibility of documents. Thousands of documents have been declared admissible on a prima facie basis. I provide one example. Footnotes of the closing order have been attributed a value of authenticity simply by virtue of the fact that they are cited as footnotes in the closing order. During a hearing, the President even went so far as to state that such documents had been used during the judicial investigation. Based on that, it would be permissible to admit those documents without argument or debate. Concurrent to the hearings on the admissibility of documents, your trial chamber ruled that in the interest of public education and their edification, that it was necessary to schedule hearings on key documents. The trial chamber specified that this specific set of hearings, and there were 4 hearings on key documents, had a purpose of not to deal with admissibility, since admissibility hearings had taken place already. And for the first 3 hearings, you proceeded to inform the parties that we were not to address the probative value of documents, which was being presented by the parties during the hearings on the key documents. During the first 2 hearings, did not have the right to speak. This is crystal clear. Following that, the key documents hearing on hearings unfolded, and over time and slowly over the course of the third hearing, we were told that we would have the right to reply. However, there was a condition on this, and we were privy to this yesterday. The Chamber told us that not only were we barred from talking about the probative value of the key documents being presented by the parties, the trial chamber had prohibited my colleagues from the Nuncia team to talk about the authenticity of the documents. They prohibited them from contextualizing the documents presented by the co-prosecutors and the civil parties, either through the summoning of witnesses who took the stand or through documents that had a historical value, or by citing their own work, such as previous written filings to your Honourable Chamber. We consider that this diversion, this slip, is a sort of trap. And we are being told that since the last hearing on key documents, we have been given the message that you may speak. And I believe this is the clincher, if you will. Let's call a spade a spade. This is a form of manipulation. You've told us you may speak. And I would quote Judge Cartwright on this. You may speak on probative value. However, as we saw yesterday, these proceedings have absolutely nothing to do with an adversarial debate on probative value. Nevertheless, at the same time, in the trial chamber memorandum that was issued just before the June 3rd trial management meeting, we were told that where the Khieu Samphan team were to refuse to participate in the hearings on key documents, the trial chamber, pardon me, I'll repeat my words in order to be completely clear. In a memorandum that was issued to the parties prior to the June 13th trial management meeting before the key documents hearing, we were told that if the Khieu Samphan team were to refuse to partake in the hearings on key documents, that the trial chamber would be entitled to refuse any request for an increase in the number of pages for closing arguments, both written and oral. As a way of consolidating this sort of trap, in paragraph 10 of the same memo, 4 paragraphs on from the previous paragraph, the co-prosecutor said that in any event, the number of final pages for the final arguments, as well as the time allocated, shall not be amended. Therefore, the question that we ask ourselves is when? When is the adversarial proceedings, as provided for under Internal Rule 27, when will the adversarial hearing actually take place? When will we be able to defend Mr. Khieu Samphan based on after the 20 months of proceedings, after the hearing of some 12 experts who have appeared here, after some 6,500 documents have been considered as admitted into evidence, some tens of thousands of pages admitted into the proceedings. We cannot summarize all of this in some 100 pages of our closing arguments or make our final pleadings in 1 hour and 40 minutes. There comes a time, there was a time when we must confide our trust in the trial chamber, and we have asked to take the floor in acceptable conditions. We have asked for extensions which are acceptable in all other jurisdictions. However, one can only draw the conclusion based on what has happened in reality. That is, in practice, in reality, the defense for Mr. Kyo Sampon has been muzzled. Our team has been gagged from representing him, from speaking on the hundreds and hundreds of testimony. And based on those facts, are we to consider that we are actually taking part in a trial or as the co-prosecutors and the civil parties have showed, this is simply an international conference at which Mr. Kyo Sampon is asked to speak and give his opinion on what happened some 30 years ago? I believe that the answer is abundantly clear for us. We have developed these arguments on many an occasion. We have never diverted from this position. We have always been crystal clear. We have always stated where we were going, what we wanted, and what our analysis was. Today, the trial is drawing to an end in perhaps 1 or 2 weeks. The moment has come to draw the consequences of the decisions that you have made. We will reach our own conclusions. You will reach your own. That is it.
Mr. Prosecutor, you may proceed. Please be brief.
I'm grateful, Mr. President. I will be very brief. I rose because I want to correct the record, and in the interests of calling a spade, to quote my friend, I do want to make sure that the record is clear, both for everyone in the courtroom and for the public. What Your Honours are being treated to here is a complete and utter charade. You are presented with a series of false explanations and excuses, supposed breaches of fair trial rights. You're accused of engaging in manipulation and placement of traps. None of this bears any basis in reality whatsoever. And to address a couple of the specific points. Firstly, my learned friend alleged that Your Honours had admitted documents referred to in the closing order without permitting debate or objections. That is plainly false. Your Honours indicated that documents referred to in the closing order are entitled to a presumption of reliability, but in relation to all of those documents, Your Honours permitted the defence to make written and oral objections, which they did. Your Honours heard the objections in a series of extensive hearings. Your Honours heard our responses, and then decisions were made in relation to admission. So that claim is simply not true. It is not based in fact. As to the opportunity to make responses to documents, if my friend takes the issue with additional directions being given, or if he notes those additional directions being given to make submissions on probative value, then it was open to him to take the same course that our learned friends, counsel for Nuon Chia, took. They have been given time. They were asked to provide estimates of time that they need to make their responses. That time has been allowed. And so the claim that they've been prevented from speaking or engaging in an adversarial debate is, again, simply false. It is an untrue statement. As to the extension of the final trial brief, we see absolutely no relationship between a limitation on the length of a final trial brief and an accused's decision as to whether or not he wishes to testify, assuming he genuinely wishes to testify, a position which surely now has been negated. Now, 100 pages for the defence, 200 pages for the prosecution in relation to two accused. How does that amount to a breach of any right? How does that disturb the equality of arms? If anything, if the accused takes the view that a limitation of pages impinges on his ability to present his case, well then, here is the perfect opportunity before Your Honours and before the parties and before the people of Cambodia, to whom Mr. Khieu Samphan has pledged a promise to give responses to the allegations. Here is an opportunity to state his case and respond to questions and give his versions of the facts. They have not been gagged. Every procedural right has been respected, meeting international standards, and in our respectful submission, going well beyond to ensure that this accused and his counsel are able to state their case and that they're able to respond to the allegations. Your Honours are being presented with a false series of excuses. If the accused wishes or has elected to not testify, then that is his right. Our position is that it is not a legitimate exercise of a right to remain silent for the reasons that I stated. But if he does not wish to answer questions, that is his right, and he can stick to that right. But it is disrespectful to this court, and it is disrespectful to Your Honours, and it is a complete misstatement of the record to allege that somehow this decision is based in supposed procedural breaches, of which there have been none. Those are our respectful submissions.
The President. Counsel, it is now done with this matter. The Chamber will deliberate on this issue. President. I hand over the floor to Judge Silver Cartwright to enlighten this matter for all parties. Judge, you may proceed.
Yes, thank you, President. The Chamber has heard the various arguments on the question of whether Kyo Sampan wishes to exercise his right to remain silent, and it understands that he is declining to answer questions, even were the trial chamber to agree to the suggestions made by the prosecutors to allow more time for preparation. Instead, he is claiming some breach of his fair trial rights. However, the Chamber has afforded Kyo Sampan and his defence team precisely the same opportunities to respond to all issues at trial, and it does not accept this is a reason for declining to exercise his right to remain silent, for exercising his right to remain silent. Now, the point has now been reached where Kyo Sampan or his defence team has the opportunity, which was scheduled and notified some time ago, to comment on the key documents presented by the prosecutors or to raise their own key documents. And the President has asked me to invite the Kyo Sampan defence team to begin that presentation. Thank you, President.
Well, the first thing that I would like to do is answering an oral submission that was made by the co-prosecutors during the hearing of 24 June 2013, which regarded the presentation of key documents. And this oral submission presented by Keith Rayner was asking for document Cambodia fact sheets dated 17 March 1975, apparently prepared by the National American Security Council for a certain Mr. Bill Condell, asking for this document to be admitted pursuant to Rule 87.4 of the Internal Rules. And the document presented by the prosecutor is D366/7.1.366. During this hearing of 24 June, Anta Guissé, also counsel for Kyo Sampan, opposed the presentation of this document, which had never been put on the case file and which necessitated a submission based on 87.4. The prosecutor acknowledged that this was a new document, and therefore he asked for leave to form an oral submission to have this document put before the Chamber. And the Chamber authorized the prosecutor to present his oral submission. And you informed us that we could react to this later. Well, this is what the prosecutor said on the 24th of June. Free translation, I quote, on page 85-86 of the French draft version of the transcript, and this was at 1510 to 1512, and this is what the prosecutor said. This document is not in the footnotes of the closing order, nor in the final statements, nor in the list pursuant to Rule 80. So all I can do is ask to have this document presented pursuant to Rule 87.4, because this is in the interest of justice. So, in short, in this document, the prosecutor continues, there are 15 examples under the heading, open quotations, communist terror in Cambodia. There are examples of forced transfer and examples of executions, and this is classified as refugee accounts, and also in various American newspapers, such as the Washington Star News, and in reports of the American Embassy, and in a Laotian paper. According to us, the prosecutor continues, this document is particularly relevant for this trial. So I hope, therefore, that I have laid the foundations for my submission. End of quote. So today, we, of course, challenge or contest the oral submission of the prosecutor, and for various reasons. The first is that the submission on 24 June is not in line with the rules that you have stated to make such submissions. The second reason is that the admissibility criteria required by and defined by Rule 87.4 are not met. So the first part, therefore, we believe that the written submission does not comply by the rules issued by the Chamber. And I'd like to remind these rules. Submissions presented based on 87.4 must be presented prior and not at the last minute. And second rule, these submissions must be presented in writing and not orally. Third rule, the document must be available in the 3 official languages of the ECCC. So, regarding the time frame, I will refer to a transcript of 18 July 2012, E1/91.1 on pages 6 and 7. And this is what is said, free translation, by the Chamber. The Chamber has already indicated that any document that the parties wish to use during the proceedings and that has not received an E3 index or that appears on no document list proposed to be put before the Chamber must then address the conditions announced in Rule 87.4. And the Chamber also stated that, pursuant to the principles established in terms of fair trial, the minimum condition in order to refer to a document that has not yet been put before the Chamber or whose inclusion has not yet been requested is to be presented within proper time, a request to place this document or to ask for it to be put before the Chamber pursuant to the provisions of this rule. And I would like to quote now, to support this first quote, an excerpt of your court's memorandum of August 3, 2012, indexed E218, and I'm going to quote a passage from paragraph 22. This memorandum is titled Organization of a Trial Management Meeting in view of programming the remaining phases of the first trial. And the excerpt that I'd like to quote is the following. The requests presented at the last minute pursuant to Rule 87.4 will be, as of now, rejected. End of quote. And often you have applied this rule, in particular during a submission that was presented 1 week before a witness came to testify. And you can see that on the hearing of 8 August 2012, index E1/104.4, pages 2 and 3, that you rejected such a document, and you also rejected during the hearing of 3 October 2012, index E1/129.1, pages 678 and 79, a request that was presented the day before one of the witnesses came to testify. And finally speaking, you also rejected a request made during the day of the hearing. And this was the hearing of the hearing requesting the release of Que Sampan, and these were the excerpts of the book of the investigating judge Marcel Lemonde, who we were told that this book had already been rejected wrongfully in order to prevent Sonarun from taking a look at this book and comparing it to other documents, whereas this is not at all the case. We have not seen any official decision from your chamber rejecting the request that I had formulated to put this book before the chamber, which seems to me essential to discuss the probative value, and we're returning to this issue of the probative value of the different elements collected during the investigation, and especially the conditions in which this information was collected. And to date, 2 weeks before the end of the trial, we have no formal decision on this. We simply have a general idea in which a senior legal officer is announcing that this request will be rejected. So this is my third example. So to date, or that day, corrects the interpreter, the request had been presented prior and it had been rejected. Now I'd like to turn to the written nature of the request based on 87.4, which is necessary. And I'm going to quote a transcript from the hearing of 23 May 2012, E1/75.1, page 25. It is the President speaking here. And let me quote, I would like to say that in order to present a new document to be placed on the case file, or to be put before the chamber, it is necessary to make a written submission pursuant to Rule 87.4. The chamber will not issue a decision. Will issue no decision on a document that has not been the object of a written submission. And now I'd like to turn to a quote of the hearing of 24 July 2012, E1/95.1, page 119. It is Judge Cartwright speaking here, and she says the following. Thank you, Mr. President. And Judge Cartwright continues, you must present your request in writing. And one of the reasons why we're asking you for written submission is that the article involved, this particular document, whose admissibility was requested, and it will be impossible to take a decision before such a document has been translated, because this document was only in one single language, so that the document may take a decision in regard to that document. End of quote. And now I'd like to turn to the third condition regarding the availability of the documents in all 3 official languages of the ECCC. And now I'd like to refer to examine this condition to your memo titled List of Witnesses Called to Testify During the First Phases of the Trial, comma, the delay for filing documents in response to request E109/5. And this is a memo dated 25 October 2011, index E131/1 on page 3. And the Chamber states that the documents put before the Chamber should be available in all 3 official languages of the ECCC, period. Therefore, it is up to the party asking for the admissibility, asking for this document to be put before the Chamber to make sure that this document is available in all 3 official languages of the ECCC. Further, it is written, the Chamber requested all parties to indicate which document it wishes to put before the Chamber during the first phases of the trial, and to make sure that these priorities are communicated to ITU so that these documents or to make sure that these documents are transmitted to ITU within a reasonable amount of time. And therefore, the ability to use the document will be limited if it is impossible to translate this document within due time. End of quote. In this memo, ETH 131/1. So, therefore, I'd like to summarize. The request formulated by the co-prosecutors during the hearing of 24 June 2013 was presented at the last minute, that is to say the very same day of the hearing, and orally. And the document that they are requesting to put before the Chamber is only available in English. It's a 26-page document, and therefore, given the rules issued by your Chamber and the rules that I have just reminded you, the request of the co-prosecutor should be simply rejected. But also, and once again, this request must be rejected because the requirements set by Rule 87.4 are not met. And the admissibility criteria required by this article, therefore, are not met, and I quote the article in question. During the trial, either on its own initiative or at the request of a party, the Chamber may summon or hear any person as a witness or admit any new evidence which it deems conducive to ascertaining the truth. Any party making such a request shall do so by a reasoned submission. The Chamber will determine the merit of any such request in accordance with the criteria set out in Rule 87.3 above. The requesting party must also satisfy the Chamber that the requested testimony or evidence was not available before the opening of the trial. End of quote. So, in view of this rule, therefore, a request has to be reasoned and also prove that there was all necessary diligence was exercised. And, of course, the document must meet the admissibility criteria of Rule 87.3, which here is not the case. First of all, I will speak about, unless you want me to do so after the lunch break, because I see that it's almost 12 o'clock, and I still have a lot to say.
The President. Thank you, Council. The time is now appropriate for a lunch break. The Chamber adjourns now and will resume by 1:30 this afternoon. Security guards are instructed to bring Mr. Kyew Sampon to the holding cell downstairs. and have him return to this courtroom before 1:30. The court is now adjourned.